Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before we get to our exciting case today, quick reminder, don't forget to like us and follow us on Facebook and YouTube, Instagram, wherever you're watching. And if you find this video to be helpful or know someone who may, please hit that share button or that save button so you can find it again. All right. So today's case is a very interesting one. It is about a client currently residing in Douglaston, New York, which is in Long Island. She is a native and citizen of the Dominican Republic. She entered the US in 2018 with a B2 visitor visa. She did not leave when the visa expired. About 3 months after entering the US, she married her US citizen boyfriend in the Bronx, who she had been dating since about 2012. They had been in a long distance relationship. About 5 months after that, and now she's out of status, she was on a Greyhound bus in Florida. Now, this is really the definition of bad luck. This is someone who's been in this country past her period of authorized stay for about 2 months. And she went down to Florida and I think to visit family, and then was coming back up to New York on the bus when ICE pulled the bus over and checked everyone's papers on the bus. And because she was out of status, she was pulled off the bus and detained. Yes, ICE can do that. Immigration can do that. Our government can do that. It does happen near the borders a lot. Florida's not the border you normally think of for that to happen, because that doesn't border another country, just borders the ocean. However, there are a lot of immigrants in Florida, of course, and they were on Route I-95, which is a known route for drugs and trafficking and all of that. And that I-95 stretches all the way from Florida into, I think, Maine, actually. So you could take it all the way from the very south to the very north. So she had boarded the bus. Obviously she couldn't show she was here legally, so they detained her. She was issued a notice to appear in immigration court and remanded to custody. She then had to get a lawyer down there in Florida to file for a bond redetermination to release her, because she wasn't scheduled for court for a month, so she would have remained detained for a month. At this point, her and her spouse had already started preparing to file for the I-130 marriage petition and her green card. And she wasn't subject to mandatory detention. She wasn't an arriving alien. She had no criminal history, wasn't a national security threat. So her lawyer down there was able to get her bonded out on only $5,000 bond, and she was released pending her court date. They also immediately filed the I-130 petition. And they filed that first I-130 package with affidavits from family members and friends. There were about 4 of them. Photos. The petitioning spouse wrote an affidavit, and then some doctor bills showing in my client's name, showing she shared an address with her husband. The address was her in-laws' place, so they also had the in-laws lease, and they had written a letter saying, yes, she lives here with us. So then she was back in New York because that's where she lived. But her court was in Florida, so that's when she hired us. And we filed a motion to substitute counsel and change venue to New York. We also, before we did that, I did have one master hearing for her. And we told them that the I-130 from her husband was pending. She had, we were waiting to file for the green card. And back in 2019, they had something called the status docket. If you go back to some of my videos from that time, you may hear me mention it. Um, but essentially, it's not really being used anymore because they're dismissing cases instead. It's almost like an administrative closure. I've talked about that a lot before in my previous videos, where you don't, it's a little different than administrative closure. Where administrative closure means you're still in court proceedings, but you don't have a future court date. Whereas a status docket is you technically don't have a future court date, but you have a date to report. So I think it gave us 3 years. It said if by this date, like 3 years later, you need to tell us either the I-130 has been approved, it's been denied, it's been withdrawn, whatever the case, it's still pending. You need to tell us what's the situation is, and as long as you write in and tell us before this date, then we'll give you an extension if needed on the status docket. If we don't hear from you, then technically this is your court date. So, of course, we make sure always in those situations to reply on or before the court date. Generally, if something's approved, like the I-130, we'd respond as soon as that was approved. So yeah, the status docket not really being used anymore, at least that I know of. Generally, the only reason that helps is if you have a work permit based on something pending. Otherwise, you'd probably want your case dismissed. So we then filed her green card application with her work permit application. And while all of this is pending, the I-130, the green card application, all of it, her and her husband started to have problems. And it turned out she learned that her husband was using drugs a lot. And he just, they had a long distance relationship for a long time, but he just wasn't the person that she thought he was. And they decided to separate. And they got divorced in 2021. Now, as her attorney, we didn't file the I-130, so we never actually technically represented him. We did file a divorce. It was an uncontested divorce. Yeah, everybody agreed. But as her attorney, it's not our job to withdraw the I-130 petition. The I-130 petition can only be withdrawn by the petitioner. So now her ex-husband, he never wrote in to withdraw it. Even if we wrote in to withdraw it, we can't withdraw it for her because she's not the one. She's not the petitioner. It's not her form. So while this is all pending, the I-130 at some point with the old ex-husband gets approved. I don't remember exactly when the date was. I just remember getting it and being like, that's interesting. And because I don't think they even had an interview, if I remember correctly, which back then was surprising. Although I think back then there were a lot of people in proceedings because you would still have the green card interview, so they weren't interviewing as much. So, and remember, this was before COVID too. So they were divorced around February 2021. Her and her, she had another boyfriend that she had been dating for a while at the time. In fact, she had gotten pregnant, and they had fallen in love. And essentially, they decided to get married in June 2021. And he, of course, also a U.S. citizen. So we had to file a new I-130, even though the first one was approved. It was the wrong spouse. I've talked about swapping out the I-130 with like the VAWA applications before as the underlying petition for the green card. You can swap out I-130s too, technically. So that was our plan. So we filed a new I-130. This time we had birth certificates for 2 children that my client and her new husband had together, which whenever I talk about the strongest type of evidence you can submit, having children together is at the very, very, very top. And you could say, well, it sounds like she got might have gotten pregnant when she was still married to the other guy. Well, they were clearly having problems, and that is a little suspect. However, they did then have they did intentionally have another child um, together, so it became a non-issue. We submitted a cable bill for their residence, an affidavit from petitioner's father, and a joint bank account statement. Not a huge filing of evidence, but the important thing to remember is that they have two kids together that live with them. They all live together as a family, and that again is really strong evidence. And if you're watching on Instagram, I apologize if the connection is giving you some issues, but you can join us on YouTube or Facebook. So in February of 2022, the Department of Homeland Security, not us, but Department of Homeland Security, filed a motion to dismiss her removal proceedings based on her ability to adjust before USCIS based on the approved I-130 from her first husband. Now, we're not required while it was on status docket to necessarily tell them what's going on until it was time to report. It wasn't time to report yet. It got close to that time, but it didn't get to that time. So we were waiting for the I-130 to be approved for the second spouse before we filed to dismiss the case. But DHS filed the motion. It was we didn't oppose it, obviously. It was granted. And so we were waiting at this point for the case to now get transferred back from the immigration court to USCIS because the application for the green card dates back to the first spouse, as I said, and that was filed initially with USCIS. So, but then it gets transferred to the court when you get into court proceedings. Now it has to go back to USCIS. And it was actually interesting because DHS actually wrote that they're asking that the court send back the file to USCIS without us even, I mean, we might have been prompting them. I can't even remember at this point because we were having a lot of trouble, especially then and still with getting cases that were dismissed back to USCIS. It's been a real frustration for a lot of people. It's because they have very poor communication between the two agencies. You have EOIR, Executive Office of Immigration Review, and USCIS, United States Citizenship and Immigration Services, two separate agencies all under the executive branch, and they have some very big communication problems they need to work out. So it was taking, I mean, the case was just not getting transferred and we weren't getting answers. And anyone watching out there going through the same situation, this might be a path you could take. We normally do not like to refile applications when another one is still pending. So her green card application was out there, it was pending. Filing a new green card application was a little risky in the sense that actually exactly what we thought might happen is that USCIS got confused. That's really the main risk. So we filed this August 2022. And the client had to repay all the filing fees and everything. And the other I-45, maybe one day we'll get the denial, maybe one day we'll get an approval, which would be even more interesting. But essentially, it did work because their case finally started to move along again. And last week, they were called into an interview. And this wasn't surprising because if you get married after you're put into removal proceedings, it's almost guaranteed until more recently that you'd have an interview. And not only would you have an interview, you'd have a Stokes interview, which is where your first interview, you're separated. So you and your spouse are called in separately, asked the same questions, then brought back together at the end, and then asked to explain any differences in your responses to the questions. much more stressful interview than you two sitting side by side. So we weren't shocked when they got the interview notice, but we weren't really sure what to expect. So last week, Aaron went with them to the interview, and it was over. I remember I was sitting there, and um, less than an hour after they left the office, he texted me that it was done, they're approved, and I was like, "That was fast. What?" Um, Essentially, he said that USCIS called them in for the interview because they were confused. They thought that she was adjusting based on the first I-130 approval for the first marriage. Clearly, this was a different person. So she thought that the USCIS officer thought that my client paid one or both of the spouses, but that quickly became clear that was not the case, considering, again, they had 2 children together. And they explained the whole situation with the ex-husband and what went down with that relationship, that it was a legitimate relationship, it didn't work out. So the interview ended up being really quick once that got cleared up and they were approved. Um, so this client started off being really unlucky, getting detained only a couple months after overstaying her visa. And trust me, I have clients who've overstayed their visa 20 years and have never even had that scare of being detained. So I definitely think it's unlucky. But we also found out something very interesting, and I'm probably going to make another video maybe today about this because I think it's important. We learned from USCIS, and we're not positive if it's nationwide or just in the New York jurisdiction, but they're not doing really interviews anymore for green cards or marriage cases. Uh, People are still getting called in, but those cases that are being called in are usually ones that they think there's some type of fraud, or they're planning to deny, or they're like this case, there's just some confusion that needed to be cleared up. Um, it's good because it makes things go quicker. This case with the interview was a year. For or a year from when we filed for the green card. But what it also means, and this is why I'm probably going to make a video, is that your chance of getting approved now without an interview is so much higher. And that saves you time, money, and stress. And in order to do that, though, you need to have your forms filled out properly. You need to have all of the evidence that's required. You need to have a lot of evidence as well, which, in my opinion, is even more reason to hire an experienced immigration attorney like us. And if you're watching on YouTube, Facebook, our contact information is scrolling across the bottom of your screen. If you're watching on Instagram, if you go to our bio page, you can find our information there. And the reason I say that is because our cases keep getting approved without interviews. This is the first interview that a client's had to go to for a green card based on marriage or family in general in since this policy started. I don't know exactly when, but it's been, I'd say, probably a year, maybe less. I can't remember the last time a client had that we filed for initially had one of these interviews. So we know what types of evidence USCIS wants to see. We know how to fill out the forms properly, and that is what cuts down on putting yourself at risk of having to be interviewed. And now that there's this literal policy out, it's an internal policy. They don't always announce it, but when we go there, we always talk to the officers to find out what we can learn, what's going on there. With this new policy, it seems that if you fill out the applications right and have a good amount of evidence and all of the evidence required, then you have a really good chance of getting your interview waived. So check back today or tomorrow. I'm gonna try to do this video maybe right after this if I can. And I will talk about how you can prepare your application so that and your evidence in a way that can not guarantee you're not going to have an interview, but put you in the best position possible to have that interview waived. But again, there is no replacement for an experienced immigration attorney. On that note, that is all for today. Our contact information, again, YouTube, Facebook, scrolling across the bottom of your screen. Instagram, go to our bio page. You can find it there. And don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. Go ahead, please hit that share button or save button if you find this video to be helpful or know someone who may. And don't forget to look out for that video coming out hopefully today about how you can put yourself in the best position to waive your marriage interview. Thanks for watching and have a great day.